Hold harmless agreements are powerful legal tools in Texas that can protect you from significant liability risks. These contracts transfer risk from one party to another, providing a shield against potential legal claims. A hold harmless agreement is a contract that releases one or both involved parties from legal claims within the state of Texas. Both parties must sign this agreement, which outlines specific activities or transactions for which legal action cannot be taken. These agreements are commonly used when one party agrees not to sue the other for damages, losses, or expenses resulting from their interactions. In construction contracts, for example, a subcontractor might provide a hold harmless agreement to the builder or contractor, essentially providing insurance for all work performed by the subcontractor. This minimizes the risk of lawsuits and allows parties to file indemnity claims if injuries occur on the job. Texas recognizes three distinct forms of hold harmless agreements. Broad form agreements require one party to assume all liabilities, including those caused by the other party's negligence. However, these are typically unenforceable in Texas construction contracts due to the Texas Anti-Indemnity Act. Intermediate form agreements hold one party responsible for all liabilities, except those arising solely from the other party's negligence. These are more likely to be upheld in Texas courts. Limited form agreements, the narrowest type, make the indemnitor responsible only for damages they directly cause, making them the most enforceable in Texas. When should you consider using a hold harmless agreement? These contracts are valuable when you want to avoid legal action based on your actions, when someone is using your property and you want protection from liability, or when a company or individual is providing services on your behalf and you want to avoid responsibility if a third party is injured. Beyond construction, hold harmless agreements are commonly used in Texas for real estate transactions, special events on private property, sports or recreational activities, independent contractor arrangements, and equipment rentals. In each case, the goal is to clearly assign risk and prevent costly legal disputes. Creating an effective hold harmless agreement requires specific information. Your agreement should include definition of terms, indemnification terms, claim notice procedures, liability details, insurance requirements, duration of the agreement, and the governing law. You must clearly identify the party receiving protection from liability and the party providing that protection. For a hold harmless agreement to be enforceable in Texas, it must meet several legal requirements. The agreement must use clear language that explicitly states the scope of indemnity. Terms should be conspicuous, possibly bolded, capitalized, or separately signed. There must be consideration, meaning an exchange of value or benefit. The agreement must comply with public policy, which generally means it cannot indemnify a party for intentional misconduct or gross negligence. And in construction contracts, it must comply with the Texas Anti-Indemnity Act. Insurance provisions can strengthen your hold harmless agreement. Consider specifying the types and minimum amounts of insurance each party must maintain, requiring additional insured status, mandating regular proof of insurance, and including a waiver of subrogation to prevent insurers from seeking reimbursement after paying claims. Hold harmless agreements in Texas are enforceable when clearly written and compliant with state laws. While templates are available, consulting with an attorney ensures your agreement meets all legal requirements, especially in regulated industries. Remember that indemnification involves reimbursing for losses, while hold harmless means not holding the other party legally responsible. These concepts often work together in these agreements. By understanding the key uses, types, and legal requirements of hold harmless agreements in Texas, you can better protect yourself and your business from potential liability risks.